So today I want to talk about what it means if an adult son or daughter would like to petition for one or both of their parents to immigrate to the US. So this sounds like it might be a really straightforward process, but it's not always the case. So it's important for me to explain quickly what it means when it is straightforward and relatively simple with no complications versus what it can mean if it's more complicated, as well as what it can mean if the parent is not actually eligible to file for a green card through one of their children or adult son or daughter. If a parent has entered the United States without papers, without a visa, without inspection, then oftentimes a child, when they turn 21, can file a family petition for a parent, which is called the I-130 petition, but then the problem starts there. So if the parent's in the US and they did not enter with a visa, most times any individual in that situation will actually have to depart the US and go through what's called consular processing for their green card. Well, the issue is that the moment that parent leaves the United States, they're going to be subject to a 10-year bar before they can lawfully return to the US with a green card. And so the issue is that if that parent is not eligible to first file a waiver to ask for forgiveness, they then won't be able to complete consular processing because they would risk departing, going to an interview, and then being denied because they have a 10-year bar. The issue there then becomes that a child cannot, no matter their age, a child cannot ever be a qualifying relative for a parent who's trying to ask for forgiveness for their unlawful time in the United States. So that's always where we have to start the conversation, is to first determine, did the parent enter with inspection, with a visa? If not, is there a chance that maybe they held TPS status at one time and were able to leave and return to the US with an advanced parole document, which is very common and that happens as well. And then finally, the other option that we have to consider is there a chance that that parent is grandfathered under Section 245I of the Immigration and Nationality Act, which, if you've ever had this conversation with an attorney trying to give you guidance, 245I for short is a law that had a sunset date on April the 30th of 2001. So I will have conversations with family members and I'll say, look, yes, you entered the United States in the mid-90s, late 90s, early 2000s. Is there any chance that you had a family member in the US, usually who's older, an aunt, uncle, grandparent, parent, something like that, who may have filed a petition for you or for another family member where you were included back before April 30th of 2001. And if that's the case, then we can start talking about eligibility again to file for a green card in the US. Alternatively, sometimes we have situations where parents have never been in the United States at all, but the son or daughter's in the US and they're a US citizen and they want to start the process. Well, that can be much more straightforward, but it's also important to know it can take a good couple of years. So when a son or daughter is going to petition for their parents who are abroad, have never been in the US, no legal bars to entering the United States, it still doesn't necessarily mean that it's very fast. Though in the grand scheme of things, relatively speaking, it's still fast compared to many other processes. That process, while more straightforward generally speaking, still also involves the requirement for the son or daughter to show that they're eligible to financially support their parents who are seeking admission into the US. It's called an I-864 affidavit of support, and it's where you have to provide your financial information, tax returns, paycheck stubs, proof of your employment. And as a reminder, that 864 affidavit of support applies to both family members who are immigrating from outside the US with consular processing, as well as adjusting their status in the United States. No matter which pathway, the financial eligibility to support your parent applying for a green card is always going to be a requirement. So I hope that helps to provide some understanding as to how the process can be both straightforward in one way as well as complicated in another way.